Good afternoon, Ms. Gledhill. Mr. Diaz?
Yes, Your Honor, a couple of items. I think first, initially, the easy matter, just looking at getting a new date.
How much time do you need?
I think if we could go out to November 22nd, that would be my request.
Let me just confirm, Your Honor, that that works for me. That would work for the state.
November 22nd at 1 p.m. for the next scheduling conference. All right.
Yes,
What's the
Your Honor.
next matter?
And then secondly, Your Honor, we'd like to address the protective order. We tried to address it with Commissioner Olson. He signed the pretrial protective order and basically deferred decision to the court, to you. So my question is, as a general matter, usually it's the state's motion to request the protective order. So I don't know how the court wants to handle it, if it wants the state to go first, or since it's my motion to dismiss a protective order that was granted by the commissioner, if the court wants me to go first.
I think since it's already in place, it would be appropriate to hear from you, Mr. Diaz.
Okay. Your Honor, I think that the pretrial protective order was incorrectly placed and allowed. The protective order, just so the court knows, is related to Miss Gledhill's children. They are not named victims on the case. They are three individuals, 11, 7, and 5, whose father is currently missing, and we don't know where he is, and whose mother has been taken out of their lives. I think that granting a pretrial protective order in a situation where they are not named victims of any sort of domestic violence offense, there's no domestic violence in the presence of a child or anything like that related to the case, I think it steps outside of what the bounds of what a pretrial protective order in the domestic violence context are allowed to basically be put in place. I think the state's going to argue that the children are potential witnesses, at which point in time I would just argue that with them being potential witnesses, number one, we don't know if they're witnesses yet, but generally speaking, how the court handles that is the court can make bench orders, something that don't have criminal punishments attached. I think the overall frustrating thing for me in all of this is what this boils down to is this court is, I think, the inappropriate place to handle communication between my client and her children. There are other courts that are designed to handle that, courts that allow the children who should have an opportunity to have some sort of say and they should be represented by someone like a guardian ad litem. This court, this venue, is not the place for that to happen. The children do not have representation. We don't know what they want. We understand they're young, but that's why in different settings, they're given guardians ad litem to speak for that. This order prevents any sort of venue of making any sort of modification where potentially mom could communicate with her children. I think that the request for a protective order is an overall heavy-handed kind of punishment. My client's already lost her liberty. At this point in time, it feels like the state and the city, the police agency that investigated this, are trying to set everything that my client loves on fire, essentially. To dig a little bit more into that, we know that the parents were arrested last night on no new information. Miss Gledhill's parents were arrested last night with no new information. And it just feels like everything surrounding her, they're trying to take away. I think that this pretrial protective order is a part of that. And I don't think it's the appropriate venue. And I'm asking the court to remove the protective order and allow for appropriate courts to take that decision over. And with that, Your Honor, I'll pass to the state.
Ms. Pauls?
Yes, Your Honor, it's the state's position that the pretrial protective order is warranted. The case involves domestic violence. It's obviously very serious allegations against the defendant. And she is in fact the mother, the children's mother, and the victim in this case is their father. However, as Mr. Diaz indicated, at the very least, the state is requesting a no contact order, in this case, preventing the defendant from having contact with the children. The basis for this request is the fact that that this is an active and ongoing investigation. These children are in fact potential witnesses. And the state is in fact open to readdressing a no contact order in the future once the investigation is more complete and the children on advice of potentially of a therapist. And I thought I'd be helpful to update you regarding the children's status. So they are currently in DCFS custody with a temporary placement with family. I believe the plan is for the children to start engaging in therapy, in addressing the loss of their father and the fact that their mother has been charged with his murder. There is currently no protective order in the child welfare case. When I reached out to that team and asked them regarding the protective order, the response I received was, well, isn't there one in place in district court? So I disagree that they are the best to decide regarding contact with the children because they're looking into different reasons why to keep one in place. But in this case, it should be put in place because they are potential witnesses in the case.
But as you alluded to, that can be addressed through a no contact order just as well, right?
Yes. And again, as I stated, the state is willing to readdress this ongoingly. This does not have to be the final order in this case, and it could be readdressed at a subsequent hearing.
Okay. Mr. Diaz.
Thank you, Your Honor. Since it's my motion, thank you for giving me the last word. I think the overall frustration here is a lot of us are kind of operating kind of on the, I guess I just describe it as the back end. I mean, for me, as the attorney who filed his notice of appearance and request for discovery last Tuesday when the case was filed, I'll tell the court right now that all I have is some DNA results in a police report. That's it. I have that. We've followed up with their office several times trying to get additional discovery. They sent us a bunch of discovery and then immediately contacted us and said, no, you can't download that. It hasn't been approved for us, which gives me some concerns because it feels a bit like the state's gatekeeping in a way. So, I mean, as far as everything that the state's talking about, I haven't seen any of it, and it's hard for me to speak to it. That's why the juvenile court makes so much sense to be able to make these kinds of decisions. Ultimately, at the end of the day, Your Honor, I think what this all looks like, what the state's currently asking the court to do in a situation where we don't know where dad is, mom's been taken out of the kids' lives. The state is ultimately asking the court to criminalize a mom being able to talk to a third party and say, tell the kids I love them. Tell the kids I'm thinking about them. That conceivably would be a protective order violation. And that is wrong. In a situation now where kids deserve to hear that their mother is thinking about them and she loves them, as a mother, she can't do that. As children, they can't hear that. That's wrong. That's why the juvenile court is the appropriate venue to handle this, a place where there's a guardian ad litem to represent the children and not a blanket no contact from the mother to the children. I can't imagine anything more damaging for the children than that. And with that, Your Honor, I'll submit.
And would you have an objection then if I were to lift the protective order and issue a no contact order?
It depends on the way that the no contact order is worded. I think one of the things that's easy about this case, if the state has any concerns about any sort of manipulation or anything like that related to the children, my client's in custody. These are all happening on recorded lines. The state can gather that evidence and would certainly be used against my client if anything like that is done. But any sort of direct contact, I guess I'd leave it to the court to decide. But I do think that at a minimum, where the juvenile team feels it's appropriate, I think a mother being able to communicate with their children in some form or fashion is appropriate. And so that's a long way of saying, Your Honor, however the court decides to word it, if it chooses to go that route, I would just ask for certain caveats and deference to the juvenile court team.
Ms. Paulus, did you have a suggestion on that?
Yes, and I do want to respond, and because Mr. Diaz brought up discovery issues, and I thought I'd at least address that. So I did mention to Mr. Diaz that this is, and as I've informed the court, this is an active and ongoing investigation. We did provide his office with significant amount of discovery that he's going to have to look through. And so that is being addressed and ongoing. We'll be continuing to provide discovery to Mr. Diaz. I do want to address regarding supervised phone calls. The defendant has been charged with 5 counts of obstruction. We're addressing the fact that these children are very young and impressionable. You can't unring a bell. And again, the child welfare court, the juvenile judge will be looking at the best interest of the children, but the state has a burden in this case, and they are potential witnesses in this case. With an active and ongoing investigation, the state again asks that you put in place a no contact order with the children that can be readdressed at that hearing on the 22nd.
Okay, thank
Your
you.
Honor, pretrial protective orders for witnesses is incredibly uncommon. Just a blanket pretrial protective order for any sort of witness. It's uncommon. These aren't named victims, Your Honor.
I understand. So I understand why Commissioner Olson put the pretrial protective order in place. I'm going to lift the pretrial protective order because I don't think that I think technically it could be in place, but I don't think that's the intent of the statute. However, I am going to put a no contact order in place, which I realize for now practically is the same thing, although it takes away some of the potential criminal penalty. I'm not willing to carve out any exceptions today to that. If, as the case proceeds, or as counsel can stipulate, I'm willing to carve out exceptions to that. Because I do recognize, that is a limitation not only on Ms. Gledhill, but also on the children, and that can be detrimental to them as well. So I'm willing to revisit it, but I'm not willing to give exceptions today.
So I guess my only real question related to caveats, would the court be willing to just throw something out there as approved by the juvenile court team or as approved by a juvenile court judge?
I don't think I'm ready to go there today.
Okay.
But if you want to talk further with Ms. Paulos about how that might be crafted, I mean, I'm pretty open to things when counsel stipulate to them. And so if you can come up with a effective, creative way to address both my concerns, the state's concerns, and yours. As the state pointed out, I do have a number of obstruction of justice charges here, and that gives me some pause in when we talk about communicating with potential witnesses. Any other issues we need to discuss?
No, Your Honor.
Okay, thank you.
And I guess, well, actually, yes, one more thing.
Okay,
Would the court be willing, we all know how the recommendation is going to come back, but just so the court has some background information, given that we haven't addressed detention, would the court be willing to order a release recommendation report?
yes, I will request the issuance of a release recommendation report.
Perfect.
We'll have that for the next hearing.
Great. Thank you, Your Honor.
You're welcome.
If I could be excused, Your Honor, thank you. It was nice
Yes,
seeing
thank you.